And Kira or Eliza, if you want to start.
Sure. So this is a public legal education presentation put on by the Western Community Legal Services, also known as CLS. I'm Kira,
I'm Eliza.
and we will be delivering the presentation today. Greg is review counsel at CLS, and he is with us here tonight as well.
Good evening.
CLS is a legal clinic aiming to increase access to justice in the London community. The CLS accepts cases in the areas of criminal law, family law, provincial offenses, and tenant rights and civil disputes. Today, we are going to be talking about family law issues. The goal of this presentation is to help the community by explaining what certain legal terms mean and to give a better understanding of the court system. Specifically, we will be talking about what parenting time and decision-making mean. We will be answering questions of what parenting, why those terms matter, and how they can be used in practice, and what happened to the terms custody and access.
So we're going to start today with a land acknowledgement. We at Community Legal Services acknowledge that Western University is located on the traditional lands of the Anishinaabeg, the Haudenosaunee, the Lenapehouk, and the Chinookaton nations, on lands connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. The Dish with One Spoon Wampum is an inter-nation peace agreement between the Anishinaabeg and Haudenosaunee peoples that reflects the commitment to share equally in land and resources and to not take so much as to deprive others. It asks that we be stewards of the land, sharing and caring for it equally, so as to ensure that it will be there for the generations to follow. In the words of Bumgizik Isaac Murdoch, it's not a rights-based relationship or agenda, but it's a responsibility-based friendship that we have with each other. The lesson of the Dish with One Spoon Wampum should guide the way we interact with the land we occupy, and it provides guidance for our conversation about parenting time and decision-making today. I invite you all to reflect throughout our talk on how reciprocity, responsibility, and stewardship emerge as important considerations with regard to shared parenting. With this, we respect the long-standing relationships that Indigenous nations have to this land, as they are the original caretakers. We acknowledge historical and ongoing injustices that Indigenous peoples, First Nations, Métis, and Inuit peoples endure in Canada. And we accept responsibility as a public institution to contribute towards revealing and correcting miseducation, as well as renewing respectful relationships with Indigenous communities throughout our teaching, research, and community service.
The purpose of this presentation is legal information and education. It is not advice given to the community for their specific cases or circumstances. We are also law students giving this presentation, which means that we are not able to give legal advice no matter the circumstance. At the end of this presentation, Greg will be fielding a short Q&A session. You should be mindful that Greg can't give specific advice on your circumstance, but he can give you general information.
There is no confidentiality during this presentation. This is a public forum, and anything that you say is going to be heard and seen by anyone who wants to watch this presentation. This includes people who will watch the recording at a later time. We are partnered with the Rights and Responsibilities Awareness Initiative, who are also going to help us to distribute this even further by translating our presentations into multiple languages. This being said, everything that we say today will be accessible online, and so there is no confidentiality. We ask that you refrain from giving any information about personal information or circumstances.
Without further ado, what happens when parents don't live together? What does this trigger? If you and your partner are no longer together and there are children involved, it must be determined where they are going to live, how often they will spend time with each parent, and who is going to be making the decisions for them. A breakdown of a relationship can cause an absence of a plan, so it is very important for a family to make a plan about parenting time and decision making. It provides families with predictability, certainty, and something to fall back on if there are ever disagreements that arise in the future. Today, we are going to be talking about what parenting time and decision-making are and how those two concepts are different. First, we will focus on the term parenting time. Parenting time refers to the time a child spends in their parent's care. It can include time when a parent is not physically with their child, For instance, this can include time when the child is at school or summer camp. What this essentially means is school and other activities are included in parenting time and are not calculated separately. If a child is out doing an activity during your scheduled parenting time, that is still considered your parenting time. However, transitions between parenting time can be easier for children if they take place at a natural point in the child's schedule. For example, one parent can drop the child off at school and the other parent can pick them up. This can help to avoid disruptions in the child's schedule. Parenting time used to be referred to as access. However, the term access is no longer used. It is a stigmatizing term in the sense that it may suggest that if one person is the access parent, they are not equal to their former partner who may be the decision-making parent and are just someone that their child sees every now and then. By taking out the term access and replacing it with the term parenting time, it removes an element of stigmatization and focuses on the best interests of the child and the time they are spending together with their parent. It emphasizes the idea that the other party is also a parent rather than someone who just sees their child occasionally. You may often hear parenting time referred to as a parenting time regime or parenting schedule, but it means the same thing. One example of a parenting regime is shared parenting time. Shared parenting time is a 50-50 or 40-60 split, with the child spending equal or almost the same amount of time with both their parents. Another example of what a parenting regime could be is split parenting time, which refers to circumstances where parents have more than one child, and each parent has at least one of the children at least 60% of the time. This was once called split custody. What is also majority parenting time is when a child spends over 60% of the time in the care of one parent. This was formerly referred to as sole custody. As I mentioned, the term custody has been abandoned. The term has undertones of ownership and possession, which can be problematic when thinking of a parent's relationship with their child. Instead, we use parenting time and decision-making when talking about the care of the child. Additionally, custody was always about decision-making, but it started to be understood as parenting time as well. So by taking the custody component out, it is much more straightforward. Primary care also means majority parenting time. Primary care is often used in the child support context, and it means that the child care is looked after by primarily one parent. If you have primary care, it means the child spends over 60% of the time with you. It also means the child is entitled to child support from their other parent. However, only the income of the other parent will be taken into account when determining the amount of child support. As I mentioned earlier on, the term access is no longer in use due to the stigmatization associated with the word, but referred to a parent's right to spend time with their child, usually not the parent with whom the child primarily lives. If you are a parent who had access, you now have parenting time.
Now that we've learned a little bit about parenting time, let's talk more about decision-making. So decision-making is the right to make significant decisions about the life and well-being of a child. This may include decisions about a child's religion or health, education, culture, or even major extracurricular activities, especially if they're costly. It's important to remember that decision-making in a family law context does not refer to everyday unimportant decisions, like what the child has for lunch that day. It does not mean that a parent or guardian with decision-making responsibility has ultimate veto power over every issue. Instead, decision-making refers to the major and meaningful decisions that come up very rarely in a child's life. Let's look at some types of decision-making arrangements. So first up, we have sole decision-making responsibility. This means that one parent is responsible for making all major decisions about a child. Next is joint or shared decision-making. This means that both parents share the responsibility to make major decisions about a child's life. This involves cooperation and communication between both parties so that those decisions can be made together. Lastly, there may be a duty to consult in decision-making. This means that before a parent can make a major decision about their child, they need to discuss that decision with the other parent. An agreement about duty to consult will often say what happens if the parents don't agree. For example, there may be a clause that states that in the case where the parents are not able to come to an agreement, say parent A has the final say in decision-making. So why do these terms matter? You may have heard the terms access and custody before, as Kira mentioned, and now we use parenting time and decision-making instead. These terms matter because they formulate a plan that everyone, especially the child, can rely on. They also help to clarify the roles of each parent and allow for everyone to know what their job is when it comes to the life of their child. By distinguishing between parenting time and decision-making, we can also best tailor the specific roles of each parent to the needs of their child and situation. For example, there may be a shared parenting regime where each parent has equal time with the child, but only one parent has primary decision-making responsibilities. One thing that it is very important to remember about parenting time and decision-making is that they are two completely separate terms that do not determine one another. Parenting time does not determine decision-making, and decision-making does not affect parenting time. The decision-making parent does not have the discretion to change or alter a parenting time agreement that is already in place. While some facts may be relevant to both a decision about parenting time and decision-making, they are completely separate considerations that the court will undertake in separate conversations. The distinction is there to help maintain routine and stability in the life of a child. Ultimately, the goal is to provide whatever is in the best interest of the child, and distinguishing between parenting time and decision-making helps the courts do just that.
There are different examples of what parenting time can be, who has primary care, and who has decision-making authority. In this example, Bob has a child named Jim with Stacy. Bob and Stacy separated a year later. During the separation, Bob got a court order saying he has Jim in his full-time care. This means Bob has primary care and has Jim over 60% of the time. In the court order, Stacy could have a visit with Jim in the community for 4 hours every Saturday. Stacy has parenting time. Although Jim is not physically in her home, he is still in her care for those 4 hours. At this time, Stacy can make day-to-day decisions regarding Jim's care, but she does not have sole decision-making authority. The order also states Bob has a duty to consult with Stacy on all decisions relating to Jim's well-being, but he has final authority. Bob therefore has decision-making authority with a duty to consult. As Eliza mentioned earlier, it is important to keep in mind what decision-making is for. It isn't something granted by the court for a parent to make day-to-day decisions about arbitrary things. Decision-making has to do with major decisions. However, decision-making doesn't come up all the time. For instance, if both parents have the same religion, the issue will probably never come up. Or if neither parent has a strong view of where a child goes to school, it will also probably never come up.
In this example, Jose and Lucy are parents to Daniel. They have agreed that parenting time will be shared 50-50, where Daniel goes back and forth between their homes every other week. They have also agreed that they will have joint decision-making. This means that decisions relating to Daniel's health, religion, education, culture, maybe significant extracurricular activities, will be made by Jose and Lucy together. Additionally, they have agreed that neither of them can make major decisions relating to Daniel unilaterally. You can see that this example differs from the situation of Bob and Stacy, where Bob has primary care and sole decision-making authority with a duty to consult Stacy on all major decisions. Jose and Lucy have shared parenting time and joint decision-making authority.
We have talked about all these terms and given some examples of parenting arrangements. So how is parenting time and decision-making decided in court when parents can't agree? As the star on the slide says, the ultimate consideration is the best interest of the child. This is the golden rule and the ultimate consideration for courts. Courts try and look at it through the child's lens. It is not whether parent 1 wants the child more than parent 2, or who has the nicer house and cooler toys. There are a host of factors that can be considered in determining the best interest of the child, and that can be found in Section 24 of the Children's Law Reform Act. It is what a court calls a non-exhaustive list. While the courts consider factors you see on the slide, such as a history of abuse or how often a parent currently sees a child, it doesn't stop the court from considering other factors, such as a child's age or maturity.
All right, well, now we're going to go into our question and answer period. Please remember that Kira and I, as law students, cannot give legal advice. And while Greg Perrick, our legal counsel, can, he cannot in this, this forum because there is no confidentiality. So we're going to hand it over to Greg, and we'll ask that anybody who has questions, go ahead and ask those now.
Okay, thanks, folks. I just want to make sure that I'm visible on the screen. I'm seeing a nod, so I assume I'm visible. So if anybody has any questions that they want to send through in the chat, or if you want to unmute and not do video, if you want to do video and unmute, that's whatever you are comfortable with. I see iPhone raised hand. Do you want to do it in chat, or what is CAS? I'm going to answer that question first. Just I see in chat there. CAS is Children's Aid Society. Here in London, we have the Children's Aid Society of London and Middlesex. In other regions, it may be called something different. I used to practice in St. Thomas, and it's called Family and Children's Services of St. Thomas and Elgin. But CAS, when you hear that in a court context, it generally means Children's Aid Society.
Hi, I'm iPhone. I was going to ask, what happens when CAS is involved and the other parent has been told that they can't see the child without supervised visits? They've instructed that, so how, and they're telling me, the other parent, that I should go to the courts and get primary custody, but I have been told by the other parent that if I do that, he will fight me tooth and nail, even though CAS is involved. So how do I go about that? What will the courts look at in that case?
So good question, interesting question. And it's not uncommon that you'll get some direction from CAS if they believe that a child is at risk of harm if they see the other parent. And that is information that you do have to take into consideration, because oftentimes CAS, a CAS worker would say, you're putting yourself in jeopardy, your care of the child is being put in jeopardy if you make this parenting time happen, even though we've said don't do it. Now on the flip side, if you're in court, I've had experiences where the court is like, unless I hear from CAS through some kind of affidavit or some kind of court intervention, I don't frankly care what they're saying on the other side of it. So I need evidence from them that they've said that, this is what you need to do. So again, I can't give specific advice on what you should do. And I appreciate that can be frustrating, but know that it's not just an automatic kind of allowance to you that you could not foster parenting time, or any parenting, or any parent in the same situation. I'm obviously not laying that at your feet, but the short answer is it's not as simple as just, okay, CAS said you can't see the child or children, so sorry about your luck. And I do get, the other alternative would be to go to court, right? And that's what you need. Get a court order saying, CAS is saying this is it, we need the court to intervene. And you are right you are right in that anytime you make a claim to court, you are naturally opening it up for the other side to to make a claim of their own. I mean, that's unavoidable, frankly. So, I mean, as much as I would like to give you specific advice on that, those are kind of the considerations that you really have to keep in mind.
Thank you. Quick follow-up was, I've been told, because I don't qualify for legal aid, that I would have to put down like a $5,000 retainer. Is there any other options for families that don't have that kind of money to get a legal representation?
Well, there's certainly, and I think one of the last slides after the question and answer period is some references, or some references and referrals to call or review. And I don't say this to, get business for community legal services. And in fact, we're at cap now, but a part of community legal services role is that, there are folks who don't qualify for a legal aid certificate, but are on the bubble. And we have some discretion to assist in that. So you would have to call community legal services, but there are other, there's the lawyer referral service, there's the family law information clinic, and we have some contact information at the end of the slides that will do that. But I mean, no one's going to stop you from calling community legal services to see if you financially qualify.
Thank you.
No problem. I see a chat question. When does parenting time start on school days? If one parent has child Tuesday night and drops them off at school, and parent 2 picks some kid up after school, is parenting time for parent 2 start once the child is dropped off at school or picked up after school? Yeah, that's interesting. That's an interesting question. Kira, Eliza, and I were talking about that specific issue earlier, before we did the presentation. There are differing, I think, kind of opinions on that with respect to case law. But I mean, from my opinion, the parenting time starts when the other parent picks the child up, right? So so you can imagine, if there's a schedule where I have the child in my care, I drop them off at school, and a court order says that my spouse, my former partner, is going to pick the child up at 4 p.m. What if the child gets sick, right? Who, under that schedule, is supposed to pick up the child? Well, from my perspective, the other parent's time doesn't start till 4 p.m. So I mean, I would be arguing that my parenting time is still extended to that 4 p.m. whether the child is in my care or not, being at school. So it's not a straight ahead answer, but I mean that there's a lot of merit into the position that I just kind of talked about, because I think if you're the parent who dropped them off and the other parent's parenting time isn't to start until after school, you are the one who's tasked to get the child from school, take them home because they're sick, or take them to the walk-in clinic or something like that. So that would be my answer there. I just want to check your second. This can be relevant if parent 2 wishes to pick child up early from school on Wednesday. Yeah, that's again, that's squarely into what I'm saying. I mean, do you get into a push and pull about it? This is my time. You can't pick the child up. Really, what Kira and Eliza said. The question at the end of the day is going to be the best interest of the child. And you can, kind of dicker back and forth over kind of percentage of time of care of the child, but it's not a straight ahead answer. I can tell you that. Unfortunately, I wish I had a better answer for you, but the thing about the law, especially in family law, there's a lot of gray area. Yeah, no problem. Any other questions? So I see, I don't know if those are old raised hands, MD and one other raised hands. Okay.
Yeah, for me, it's a new question. I'm MD, so currently going through mediation, and I appreciate that you cannot give individual advice. But let's say one party wants to pursue majority time while the other party disagrees, wants to pursue 50-50. The issue here is that the child support and the spousal support amounts vary dramatically depending on whether it's 61% or whether it's 50%. Let's say mediation doesn't work out in this regard. What happens next?
If you're in court, you go back into kind of the contested court process. So, if mediation hasn't, taken fruit, like you said, and say the case is well started, maybe you've had a case conference already. So maybe the next step in the case is a settlement conference. And you would then be saying to the court, here are all the reasons why I think this is what is in the best interest of the child. Here's my proposal. And then at a settlement conference, the judge they don't make an order, to be clear. What they do is the best they can do is give a recommendation, and hopefully a strong one, that gets the parties to perhaps see the light as to what would happen at trial if they went ahead. So there's a lot of benefit to having a settlement conference, and that may be your next step. I don't know. I see a message here from another chat. If a lawyer doesn't show up to court and this results in an uncontested trial being scheduled, and the results of the uncontested trial are obviously in the favor of the other party, what options does one have? So this would be encroaching on specific legal advice. I urge you to go to the courthouse and speak to duty counsel. And if you can't speak to duty counsel, call the lawyer referral service number that we're going to show in the next slide here. I don't know if I can get to that.
The next slide.
Yeah, if we can just get one more. Perfect. So the lawyer referral service number there. Can you guys see that on the screen? Ira, do you see that?
Yes. Hold on.
Okay.
How's that?
Yeah. I just want to be sure that folks can see that. This is going to be recorded anyway, so if you miss it, you can go back and look at it. But that may be one way. What I can say without giving specific advice, the faster you act, the more likely it will be, or the better chance you have to either set that final decision aside, what have you. The longer you wait, the harder it will be. Okay, so I cannot urge you more to, if it's in London, go to the courthouse, speak to duty counsel, find out about the family law information clinic. Anything you can do, you explain what happened, and they can give you your next steps. But cannot stress more, the time is of the essence. Okay. Any further questions?
Yeah, I can.
Yeah, go ahead.
I think
Sorry, MD.
I can go ahead. It's MD. Yeah, so follow up on the previous question with regards to what you answered, case conference. I'm not exactly sure what that is, because I think in this case, I talked about mediation, which is voluntary.
Yep.
And then I guess if voluntary mediation doesn't work out, then what the next step is it arbitration between lawyers, and or is it just family court right away?
Do you have a lawyer?
I don't. So the mediator is the only person between me and
Have you
the
been
other
in
party.
court? Are you in court
No.
right now?
No,
Pardon?
not in court. Not in
Okay.
court.
So your option would be to start a court process.
And would that be advisable to wait until the mediation process stalls?
Well, I would, and generally speaking, if one feels like mediation is still helpful and is going to be productive, and there's a chance that you can get some results that way, I would encourage anyone in that position to continue to do so. Because what I will say for everyone in attendance and everybody watching is the court system is backed up, and it was slow before that. Where I can tell you that, I've had trials that are being booked a year in advance, a year. Like, that's not helpful for anybody. If you have children, it's not helpful for the children. Definitely not helpful for you if you have a lawyer and you're paying somebody. So, if there are some alternative ways that you can try to get something done within reason, right? You don't want to keep banging your head against a wall that doesn't make any sense. But if there is, some glimmer of hope there, and you're not, throwing bad money after good and in trying to make something work, then I would still engage in that process, because the court is stressful at the best of times, and it's frustrating at the best of times. Okay. No problem at all. Any other questions?
Yeah, I had one more.
Yep.
In terms of child support, I've been separated almost an entire year now.
Okay.
I have not received a cent in child support. As I mentioned, CAS is involved, and so he doesn't have any time with her at all. So what do I do to get child support?
So, are you in CAS court?
No, CAS just told me that he's not allowed to see her without supervised visitation, and that until he does drug testing, which he's not going to do, he can't see her.
Okay, so have you been, have you ever had a court order before?
No, and I have shied away from going to court because his new girlfriend has rich parents and they will pay for his lawyers, and I have no money to pay for lawyers. So
Okay.
I've shied away from court because I don't have the money to put out of pocket.
Okay. Yeah, understandable. And you're definitely not alone there. Court is becoming increasingly expensive and unaccessible or inaccessible for lots of folks. So I mean, I encourage you to get independent legal advice. And I know you're saying that's tough financially to do. We have some referrals on there, but generally what you need to do if you don't have a court order ever, you're just going to have to bring what's called an application. And in the resources here, there's I think what's helpful is the stepsofjustice.ca. If you go to that, there's a family portion on steps to justice. And while it doesn't go into great detail, as you can imagine, because that would start to confuse folks, it does give really basic information about what forms you need to do, generally how to fill out those forms, and get that process started.
Okay.
So if it can't happen on consent, if there's no agreement from the opposing party, which I hear there's not, you may need some court intervention.
Yeah. Okay.
Okay.
Thank you.
No problem. I wish I had better or alternative advice for you, but that's it.
Yeah.
Anything further?
Yeah, I raised my hand again. This is MD.
Okay.
So we've talked about all different alternatives. If both parties have a lawyers, and then maybe it goes to court, maybe it doesn't go to court. I hear there is a possibility of settling outside of court. In your experience, is that considerably cheaper? What are the risks of going to court versus settling out of court? What are the pros and cons there?
Well, I think I can safely say, and in most circumstances, settling out of court is cheaper than going to court. You know, I've heard it, especially if it goes to trial, and that will take a long time. But I don't think this is, I'm not telling tales out of school or giving advice, but you know, I've heard lots of judges say to unrepresented parties at trial or prior to trial, when they're trying to settle, they will, you know, explicitly say, some will say, trial will cost you $5,000 a day. Other folks may say trial will cost you $7,500 a day. And in my experience, you know, if there are parenting issues, support issues, maybe some property issues, it's going to be a multi-day trial, and that adds up real quick. And that's just trial alone. So you really want to think about you know, the cost benefit analysis of what you're trying to achieve. That said, I don't want to throw my colleagues under the bus. It helps immensely to at least get some legal advice in court. If you go without some kind of legal advice for family court, and you know, maybe you really think you're sharp and you can do it, I advise against it, because and I know it's very hard to find legal advice, but it just helps so much if you just get a little bit of advice, because it really sets you kind of in a correct direction, rather than you know, just speaking about everything that you've ever wanted to say. There are just really some certain tailored things that need to be addressed in court, and a family lawyer will be able to direct you towards those things. I know there are, you know, some of my colleagues will give independent legal advice, and what that is an hour of their advice. And some lawyers are open to that. And if you're looking at maybe, I don't want to pay a retainer, I don't want to do this or that, I would like an hour of your advice, you know, really some lawyers will jump at that. Obviously, because they know that they're going to get paid, and they know that they can give you advice for an hour, and that would be the end of it. And so a little legal advice goes a long way. Yeah, thumbs up. Thank you very much. Any other questions? Great questions, folks. I appreciate it. Just wait a couple more minutes if nobody else has any questions. And again, we want to thank Rights and Responsibility Awareness Institute and Heatham for always partnering with us and boosting the signal here. I know he's done a great job in making sure that folks who can't attend this are getting the messages, getting the instruction that they want and need with respect to their family law cases and otherwise, or their family law issues, and to for them to be able to, you know, translate into other languages, so we can further have outreach on these kind of you know, relatively basic issues. But I was saying to Akira and Eliza before we did this basic information is, while basic, so helpful, I think, for folks moving forward, because you know, family law, it can be very confusing, and just having a kind of a hold on the language of it all is very helpful. So I thank you for Ethan and his crew helping there, and just having, you know, a few of you out tonight. It is great to see, because this is available information, and I'm sure it will be helpful, even if in the smallest of circumstances.
By all means, thank you, Greg, and thank you for allowing us the opportunity to do some enlightening to this wonderful community. We are trying to help. So thanks for all of your effort for that wonderful, fruitful information. It will help a lot of people. Thank you, sir.
Thank you for that. So if I don't hear from anybody else, I'll stop the record. And you guys can sign off. If you don't sign off and you're just sticking around, I'll kick you out. Okay.
And Kira and I just wanted to say a couple of last thank yous.
Yeah,
First
no,
of all, as you said, to all you folks for showing up with us today and listening to our talk and asking insightful questions. And then again, to the folks at Rights and Responsibilities Awareness Initiative for helping us provide this resource and also for helping us translate it into multiple languages.